All rise. The Court of Appeals Division 1 is now in session.
Thank you all. Please be seated. This is the time set for oral argument in our case number CACB 220337, Warren versus Stevens. Each side is allocated 20 minutes for oral argument. Appellant, if you wish to reserve some of that time for rebuttal, you're free to do so, but you need to keep track of your own time at the podium clock. Out of respect for counsel and to avoid any embarrassment, I would ask those in attendance to make sure your cell phones are off so our proceedings aren't interrupted. We've read the briefs, we've conferenced the case, we're familiar with the record. We'd encourage you to keep that in mind as you present argument today. Our proceedings are being recorded, so please, as you approach the podium and begin, tell us your name and the party that you represent. So with that, Mr. Murray, you may proceed.
May it please the court. My name is Stanley David Murray. I'm the attorney for the appellant, Kenneth Steffens, by the way.
Thank you.
Pronounces it. He's the respondent in the lower court proceedings. And I would like to reserve some of my time, if possible, for rebuttal. Let's start with the homestead exemption order. Something that I haven't seen in my 40 years of practicing in family law. It's pretty unique, and I've never seen it used as an asset before. It's an exemption. The purpose of it is to protect the family from foreclosure of their house, as far as not the consensual liens, but the judgment liens that creditors will have. So it's prevalent in bankruptcy proceedings, of course, and it's not something that can be divided at divorce, though, because in this situation, the wife moved out of the house at the time that she filed bankruptcy, and she doesn't have an ownership interest anymore.
Well, if we're not calling it a homestead exemption in the same way that we would in bankruptcy court, it's the idea that $150,000 in the home's equity was exempt from the bankruptcy and therefore continued to be community property because it wasn't being disposed of in the bankruptcy. And so when you come back to court, when the stay was lifted on your client's bankruptcy and they were able to divide the property, isn't that property that the court then has to divide, whether you call it a homestead exemption in the same way you would in bankruptcy court? There is a pot of money that was exempted from the bankruptcy that the court has to deal with. Whether they call it community or separate is another issue, but why can't we just deal with it with taking the title of it off and saying we just have $150,000 that we have to allocate between these parties?
Because we have to make sure she qualifies for that homestead exemption claim. Under the statute, it's the owner-occupier, and if it's a married couple, if the married couple's living there and they both still own the property.
Well, did the bankruptcy court, though, include that $150,000 in the bankruptcy? I mean, is that really the trial court, superior court's determination, or is it the fact that it was exempted from the bankruptcy that we now know was settled by the time they went back to divide assets? Is that a determination that the trial court could say, well, you really didn't qualify for that, and therefore, even though that money's out there to be divided, I'm not going to give it to you? That I'm having a hard time with, if you could help me understand.
All right, I'm having a hard time, too, putting bankruptcy law with the family law, because it was res judicata as far as the bankruptcy court determining that she had sold her other equity to my client.
Correct.
When they settled that. And at that time, the value of the property was only like $595,000. So when you take off the first mortgage, the HELOC, and then her exemption, her homestead exemption, there wasn't much equity there over and above the homestead equity. So now what happens to that homestead equity that she's no longer in bankruptcy? Chapter 7 was discharged. At that point, I think it's gone unless she still lives in the house, unless she still owns the house under the qualifications of the statute, the requirements of the statute.
Doesn't that conflate bankruptcy, and you pointed it out, bankruptcy law with Title 25? Mm-hmm. I mean, what you just described sounds to me like you're saying, notwithstanding what the bankruptcy court found, by the time we got back to family court, she no longer qualified for the homestead exemption in bankruptcy court, and therefore she couldn't, wouldn't be allocated that $150.
Right, if there was a...
What path gets us there? I don't see it.
The path that gets us there is the fact that the Chapter 7 has been discharged.
Right.
So the homestead exemption doesn't exist anymore as far as creditors, because he doesn't have any creditors anymore. And now, does she still own the house? Does she still live there? That's how we figure out if that homestead exemption now applies in the family law case.
So you're arguing that the homestead exemption has, let's say there's no bankruptcy at all. You're saying the homestead exemption would apply in family court?
Well, no, because what we usually do in family court is we order the property to be sold, and one of the other spouses can buy the other out with a refi. I've never seen the homestead exemption awarded in a non-bankruptcy situation.
Nor have I. And that's why I struggle with the thought that she needs to requalify in family court after her bankruptcy is discharged for homestead exemption, as opposed to transmuting, as Judge Bailey mentioned, kind of the value of the homestead exemption to be allocated in family court.
Right. In the usual situation, she would still have an equity interest in the house if she had not filed the bankruptcy. She did file the bankruptcy. The homestead exemption attached while she was in bankruptcy. Mm-hmm. She moved out, doesn't own it anymore because the court awarded it to my client, so she doesn't qualify for the homestead exemption anymore, is my interpretation.
So her invocation, so she would have been perhaps better off to not seek to invoke the homestead exemption in bankruptcy?
She would have been better off not to file bankruptcy.
Well, I understand that, perhaps, depending on what her creditor situation was.
Right. Well, again, that's joint community debt, too, that was involved in that bankruptcy. So she got discharged on some of the debts my client still has to pay. So it's complicated.
No, and believe me, there's one thing we absolutely agree on. It is complicated, but we're asked to navigate that shoal.
And that's why I'm sorry?
Oh, go ahead.
I'm just trying to navigate, like you say, the effect of the homestead exemption, whether it still applies when she's not living there and when she's not an owner anymore. If the judge had said, sell the house, and give wife a percentage rather than a homestead exemption, then I think that would have been valid because she would have had a community interest at the time of the divorce. But the court didn't do that. The court awarded a homestead exemption of $150,000, which, by the way, was $250,000 actually in time of the trial, and now it's $400,000. So
how are you moving that number like that?
Sorry?
How are you moving the value like that?
In the statute, it's been amended several times to increase the homestead exemption.
Well, but can we look at that decree and like I was suggesting earlier, kind of remove that the judge said homestead exemption and instead consider the fact that he allocated to wife $150,000 in what the equity in the home, and then with what the court said at the time, the value of the home over $900,000, and there's a mortgage, and then there's equity left in the home. And it was probably about $500 with the more. I mean, if you take the $900 and you take the mortgage, but that's the evidence that the court had. It was, undisputed by your client at the time of trial. So the court adopted those numbers, and then has this equity to deal with. In the end, if the judge gave wife $150,000 in that equity, and your client ends up with more than that if he's able to hold on to the house through his bankruptcy, how is that inequitable, and why would we want to get involved in rejiggering that if we can take away the title of homestead exemption and just call it money and money?
Well, that's part two of my argument,
okay.
Whether it's equitable or not. My first part was whether it's even a homestead exemption. The second part would be, is it fair and equitable that she gets all of it? And we talked about offsets. We also talked about in our brief, he's paying that mortgage. He's been paying the mortgage since they separated in 2018. So there's 4 or 5 years worth of mortgage payments that he's made, and she gets the entire, I don't want to say homestead exemption, but $150,000 in equity. So the court didn't take into account these offsets, and that goes to our issue about having enough time, whether that was an abuse of discretion not to allow more time. So, yeah, once we get past that homestead exemption.
Can I, before you move past it?
Yes, Your Honor.
And I think it follows with what Judge Bailey is saying. How is it that in the bankruptcy, what the homestead exemption does is allows a party to keep $150,000 in equity in the residence. At the time, again, it's gone up. That's what she walked away from the bankruptcy with, is $150,000 in equity. You can call it the exemption, but it's actually an award of $150,000 in equity. How do I get around that? I mean, just saying, oh, it's a homestead exemption, it doesn't exist. No, she walked away from it with that.
If you call it an award, yes, I guess there's an order saying she has a $150,000 homestead exemption.
How do I get around that? Just by calling it an exemption doesn't change the actual fact of what of what it is.
Well, the bankruptcy judge doesn't make an equitable division of the homestead exemption. They just recognize that there's a homestead exemption, but she doesn't walk away with a whole $150,000 from the bankruptcy court. That's for the family law court to decide.
Well, no, the bankruptcy court said you get to keep $150,000 in equity. Take away the marriage.
Okay.
She gets to keep the $150,000. That's what the net effect of the bankruptcy was.
Well, he's in bankruptcy too, though. So
I understand.
if anything, then maybe it's $75,000.
Well, we'll probably get into that issue here in just a moment, but just staying with what I'm saying.
Yes, sir.
Do you have any answer to that?
If by having that bankruptcy discharged without having to pay off any debts or have to pay off any of the homestead exemption, I don't think it exists anymore, in my interpretation. If there was a fund that the trustee had collected from a foreclosure, let's say, and there was excess funds, then that homestead exemption would apply to that. But that didn't happen here. There's no fund, so to speak, for that homestead exemption to apply. And again, as far as the equity of that disbursement goes, my client made all those payments. There's a number of debts that should be offset that weren't discharged in her bankruptcy, the community tax debt, the HELOC, which she agreed to pay in a Rule 69 agreement in the family law court, and the HOA lien, which my client had to pay outside of the bankruptcy.
And could we account for that if we're doing the numbers I was talking about earlier and say that husband's basically retaining about $275,000 in equity in the home, that the court could have rightly just called that whole thing a wash, that instead of accounting separately for each of the offsets that husband was asking for, if the judge looks at the numbers and says, well, you've got $125,000 more in equity than wife is walking away from, that certainly is subsuming all the other kind of, the mortgage payments and the HELOC and all those other things. Could we look at the determination that way?
Yes, Your Honor, you could. But that goes to our next argument about him not having enough time to rebut her evidence.
Okay.
Especially on the home equity value.
The due process.
We never did get there. As far as the quadro is concerned, just cover that real quickly. It wasn't correctly calculated according to the law. The numbers that Mr. Dietrich used in his quadro had the wrong length of marriage, had the wrong length of employment, but yet the court adopted that plan. So we're hoping the court can set that aside. And also on remand, determine whether a quadro is even necessary. There was testimony that the present value of the pension was $240,000, and that the length of the marriage would yield only a 19% interest to the wife, 38% community, and 19% to the wife. Well, that computes out to about $49,000, so why not offset that instead of having a quadro? So we'd ask the court to remand on that particular issue as well.
Well, the parties certainly could have stipulated to do that, but is the court in error by not offsetting? Is the court required to offset?
I don't know that the parties necessarily stipulated to the quadro.
No, but they could have, is my point. They could have come to the court with an agreement that we want this $49,000 to be offset in something else so we don't have to do a quadro, but they didn't do that, correct?
No.
Okay.
Talking about the debts, again, the non-dischargeable debts that should be offset under the Bobro case, we'd ask that the court remand on that particular issue. And again, let's get to the Volk versus Brame argument. The court didn't divide community debt, and it's required to do so under 25-318. So by just foreclosing the proceedings because the time was up, the court did not meet the requirements of Volk versus Brame.
Did the court give advance notice of how long the trial was going to last?
Yes, sir, there was a minute entry that said it was 2 hours and each side would have an hour.
And was there any objection to that setting?
No, sir, not within the 30-day time limit. But then again, my client's litigation attorney didn't know that the other side wasn't going to cooperate with the pretrial statement, so she asked for sanctions. And I don't believe it's clear that Mr. Dietrich was going to testify or present argument on the quadro. That took up some time, too. So I think the judge should have adjusted those strict time limits because of these unforeseen events that happened. and
What's your
took up
best
time.
case for the proposition that that's a due process violation, recognizing Volk versus Brame found a due process violation when no testimony was received? There was testimony offered here, right?
Yeah, there was testimony, but the court didn't have enough information to equitably divide the community debts. And that's why my client needed to present his evidence on the HELOC, evidence on the tax payments that he had made, so that there was a fair and equitable distribution under 25-318.
But if your client knew how long he had and knew what evidence he needed to present, was it on him that he somewhere in that hour that was allotted, his counsel should have done it? That's not a violation of due process to pick and choose.
Well, that's what she was trying to do, was to get Mr. Stickle, the bankruptcy expert, had to testify so that she could establish that offsets were allowed and that the homestead exemption, we took the position in the trial court that the homestead should be equally divided. So Mr. Stickle, the expert, had to explain how that works in bankruptcy court.
How is this not going to, how would, if we rule in your favor in this case, not establish that anytime someone runs out of time with the time allotted, we violated their due process if we don't give them more time? I mean, we give the trial court some discretion here. That's a
Because
great deal.
I think the test should be whether the trial court has had enough information to do its duty. This time, in this situation, the court enforced strict time limits and didn't allow itself to divide community property, didn't hear all the evidence on community debts.
But that again, how does that could happen every time a lawyer doesn't use the time wisely. I don't know how this case is any different, that we wouldn't just say, basically, the rule is if the party says they need more time and they haven't covered everything, you have to give it to them. That seems to me what you're arguing.
Well, because we didn't have a chance to do effective cross-examination, which due process requires. We didn't have a chance to present direct examination on the debts, which due process requires. So, yeah, I don't want to say that every time there's a shortage of time that we get a due process argument, but look at the facts of each case. And in this situation, I think it's pretty clear that because the court did not divide community debts, that there's a problem here, and especially with the valuation of the property, which my client should have had a chance to rebut. I have 3 minutes left. I was going to reserve for...
Very well.
Thank you very much.
Counsel. Mr. Barlow.
Good morning, Your Honors. David Barlow on behalf of the appellee, Michelle Warren. This case is about a 5-year divorce proceeding that finally culminated in a favorable award to the wife, based on the family court's valid exercise of its considerable discretion in allocating community property in a divorce proceeding. Ultimately, the appeal concerns 3 issues. I think Your Honors have already touched on the importance of the homestead issue, so I'm going to begin with that one. With respect to the husband's arguments concerning the homestead exemption, there's a threshold issue that this court has to understand, and that is, I think, what Judge Bailey already identified. The use of the term homestead exemption is misleading. The family court was simply tasked with dividing a community property asset, the marital residence, and the equity therein. That's exactly what the court did. It based the division on the $150,000 homestead exemption. However, it took into account the value of the property, the mortgage, the HELOC, and the HOA lien that were all against the property. Now, both husband and wife referred to the issue as, quote, equity in the marital residence. That's from husband's pretrial statement. Wife referred to it as the $150,000 homestead protected funds in her pretrial statement. But nonetheless, the issue is the same. The community asset that was being divided was the equity in the marital residence. I do want to point a couple of issues. I think that the arguments concerning wife's ability to claim the homestead, I don't think this court even has to get there. The issue is that, as I cited to in my answering brief, the exemption for purposes of bankruptcy is determined the date of filing. That's clearly established. Both husband's Chapter 13 filing in September of 2018 and wife's subsequent Chapter 7 filing in February of 2019, those are the dates you look at to see whether the exemptions are allowed or permitted. And in both of those cases, I do want to raise the court's attention to what I think is the relevant bankruptcy rule here, and that would be Rule 4003B of the Federal Rule of Bankruptcy Proceedings, which says that if you're going to object to a claim of any exemption, you've got to do it within 30 days of what's called the 341 meeting. The 341 meeting is the meeting of creditors, where any interested party, including the Chapter 7 trustee in Ms. Warren's case or the Chapter 13 trustee in Mr. Stebbins' case, can examine the debtor. They can ask these questions that are all being raised: the intent to return to the homestead, the value of the homestead. Nobody did that. So for purposes of both Mr. Stebbins' Chapter 13 bankruptcy and Ms. Warren's Chapter 7 bankruptcy, the exemption issue is settled. Now, unfortunately, the family court used that phrase, homestead exemption, and I think that's confused the matter much larger than it needs to be done. Again, I agree with Judge Bailey. All we're doing here is we are allocating a community asset, the marital residence, and the equity therein. The only evidence that the family court heard as to the value establishes exactly what Judge Bailey was referring to earlier, and that is, we've got about $300,000 to $400,000 in equity in this property. Wife's going to get $150,000. Husband's going to get exclusive possession, and he can do with the equity what he pleases. That's it. I don't think it gets any further than that. I'm happy to answer any questions as to the case law that applies to abandonment of a homestead, if this court thinks that's necessary, or answer any questions. I think the court already raised some really valid questions as it relates to the language used in the family court order, but I'm happy to answer any questions before I move on to the other issues.
Good.
Please proceed.
The second issue is the quadro. Okay, and again, this gets to the family court's justifiably broad discretion in allocating community property. Okay, husband has argued, and I think it's important to note that this argument was first raised in June of 2018. If you look at the record 35, that the proper formula, under his view, is you only give the community credit for 6 years of this retirement asset. He's made that argument over and over and over again. He ultimately made that argument in front of the family court. Wife disagreed. Her quadro attorney, Mr. Dietrich, argued at the family court hearing that no, actually, we don't cut off at termination of employment. That retirement account still accrues, even though he's terminated, and it accrues up until the date of divorce. And that's how we get this discrepancy between whether we use 6 years or 23 years. And again, ultimately, the family court, after considering the evidence, after considering the arguments, credibility of the testimony, decided wife's quadro is to be submitted. I think that's as simple as we need to get to. It's not a question of law.
So, counsel, the quadro identifies the dates of the marriage, doesn't
Absolutely.
identify the dates of employment. Wouldn't it be fair to say that if the employer doesn't do it right, husband has the ability to come in and say, wait, we put this in, but the quadro is incorrect, and challenge that later? This is just trying to get it teed up so the division happens. And if the employer does it wrong, there's still the opportunity to say the employer didn't do it right.
Yes, Your Honor.
Did that make sense?
Absolutely, it does.
Okay.
And I think it's important also to realize, husband's argument is largely based on the fact that the employer denied this original quadro that was prepared by Mr. Dietrich. I want to point out that the record establishes that denial was March of 2021. Mr. Dietrich subsequently submitted a quadro on July 2nd of 2021. That is the quadro that Mr. Dietrich testified about at the family court hearing. That is the quadro that would ultimately be submitted to Allstate in this case. And again, if the employer wants to say, no, we don't think that the correct formula is being used here based on the term of employment, as related to, as Judge Gass already referred to, as the date of marriage, that's all fine. That can be resolved later.
Counsel, just to clarify, Mr. Dietrich provided argument, not testimony, correct?
Correct. He provided argument on that, but he did submit the quadro that he prepared. I mean, that was in front of the family court. That was something that the family court could consider. And again, I think this now is going to dive into the due process argument. So unless the judges have any questions about the quadro, I'll go on to that. But it's important to realize that this isn't your standard family court proceeding. This thing was going on for 5 years. The bankruptcy matters, as I argued in my answering brief, were largely irrelevant. Okay? The only relevance that the bankruptcy matters had was that wife had to seek relief from the automatic stay, and that the family court proceedings were temporarily paused in September of 2018 when husband initiated his own Chapter 13 bankruptcy proceeding. Once that relief from the automatic stay was granted, family court's free to do what they want. They can, again, get to the task at hand, allocating community assets. Husband's argument that he didn't have enough time, that these were, quote, complicated issues, every single one of those issues that's identified by husband as being complicated was known well in advance of this March 1st, 2022 hearing. It was known in advance of the minute entry that established and set the March 1st, 2022 hearing. That same minute entry, as judges already referred to, established every party is going to get an hour. We're going to have 2 hours for this. If you think we need more time, 30 days prior to the hearing, seek more time. Husband did not do that. And he can't say that he didn't understand that wife was not going to be cooperative. The issues have always been established as the marital residence, the equity therein, and the retirement account. So again, I think Volk v. Braun, judges already identified. I mean, that was an extreme example, 15 minutes each side to determine and take testimony. No testimony was heard. No evidence was submitted. Okay, this case is very different. Again, husband's counsel elected to use his time as he did. He brought in his bankruptcy attorney. He had his bankruptcy attorney examined for 22 minutes on an issue that I would argue is completely irrelevant. Okay? He spent considerable time on a motions for sanctions argument that the court ultimately denied. And at the end of the day, wife was able to testify as to the value of the residence, her entitlement to the equity in the amount of $150,000, and what those remaining community debts and obligations are. I would like to address a couple of points that were raised in oral argument.
Counsel, let me ask you just
absolutely.
one final point on due process. The court afforded the parties an opportunity to file supplemental briefing after the hearing as well, is that correct?
That is correct.
And they took up that opportunity, or at least had the opportunity to do that, right?
Absolutely. Yeah, and again, I think the judge's point, I mean, this isn't your typical family divorce proceeding. I'm certainly willing to acknowledge and concede that. But it's not also inherently complicated. I mean, the bankruptcy issues and the timing of that stuff happens time to time in family court proceedings. I think, the timeline is something that this court can look at and kind of understand, again, how we got to this point where the arguments are seemingly a little bit more complicated than they need to be. Husband and wife filed a Chapter 13 bankruptcy together, okay, in February of 2017. All right? November of 2017 is when wife files a petition for dissolution of marriage. Okay? Parties enter into the Rule 69 agreement that husband references in his briefs, in which wife at that point does agree, I'm going to pay for half of the HELOC payments, etc. However, 5 days later, August 20th, their joint Chapter 13 bankruptcy is dismissed, and it was dismissed for failure to make plan payments. At that point, within a month, husband turns around, files his own Chapter 13 bankruptcy on September 20th, 2018. Family court's given notice of that, pauses, obviously, the allocation of community assets and debts. And it's not until wife files her Chapter 7 bankruptcy in February of 2019. Husband does confirm a plan, and it is my understanding that that plan is set to be complete in September of 2023, at which point he'll receive his discharge. And then, again, I want to kind of go back just a little bit to the homestead argument, because I think it's important to recognize what was happening in wife's bankruptcy. She claims her exemption. Trustee does not object to the exemption. She schedules the value of her marital residence the exact same as husband did in his individual Chapter 13 bankruptcy, the exact same as they both did in their joint Chapter 13 bankruptcy. They both list the HOA lien, the HELOC, the first mortgage. All of that is consistent in all three of the petitions. And then husband comes into the Chapter 7 bankruptcy, and he negotiates with the trustee to purchase non-exempt equity. Okay, that's what he gets out of it. He only paid $5,000 for that at the time, okay, in addition to getting interest in an LLC and an interest in a 2006 Honda Civic. But nonetheless, that's important because that's what the family court now considers when they are, 3 years later, allocating the marital residence and equity therein. They know that husband has already purchased the non-exempt equity. They know that husband is going to be awarded exclusive possession. So all that's left is this $150,000 amount that wife was seeking, and that's what she was given. So, unless the court has any further questions, I think I've made all my points that I'd like to make.
Thank you, counsel.
Thank you.
Mr. Murray, rebuttal.
May it please the court, Stanley David Murray again for the appellant. On the homestead exemption issue, the question was whether that was an equitable division. And I read the decree, and I noted that the reason the judge made that order was because she found that husband's bankruptcy prevented wife from getting the full equity in the house. That's not correct. It was her bankruptcy that resulted in her losing that equity. So it's almost like the judge was awarding a larger share of the homestead simply based on a 25318C, unusual expenditures or waste, which didn't apply here. On the matter of the quadro, in the Kelch case, you can't give away sole and separate property. The quadro has to be calculated based on the length of the marriage, and the Dietrich quadro doesn't do that. It expands her interest to more than just the community interest that she's entitled to. And then, yes, there was supplemental briefing, but it did not allow for any extra exhibits or testimony, so we're still back in the same boat that we were in before.
Can I just ask you one more question about the quadro?
Yes, Your Honor.
If you were to read that quadro as giving Allstate the dates of the marriage, but leaving to them, who presumably would know when your client was employed there, could it be read in a way that isn't limiting the amount of time in the numerator to just the time of marriage? I mean, could we read it that factually they were giving Allstate a fact that it couldn't know, which is the dates of marriage, to compile with information it did know, which were the dates of his employment, and make the calculation from there? Could a right calculation be made if the quadro was read that way?
Actually, I think they do have that information. Trial Exhibit 5 is the Allstate letter. It talks about the dates of marriage and the length of employment and the present value. So, yeah, fingers crossed that the plan administrator would correct any errors. But they're not going to do the corrections. They're going to kick it back out and say, do this over again. It's causing further delays.
Okay.
And so,
fair enough.
yeah.
Thank you.
Thank you.
Thank you, counsel. We appreciate your briefing. We appreciate your oral argument today. We'll take the matter under advisement. We'll issue a ruling in due course in writing. We're going to take a recess while we set the courtroom up for our next oral argument. Thank you.